All right, this is our 20th video, and in this one we're going to be talking about the Sixth Amendment and the Eighth Amendment. And of course, you've got to ask, what happened to the Seventh? The Seventh deals with federal criminal civil cases, and so it really doesn't fit in with the discussion of civil liberties and civil rights because that's about criminal stuff. So therefore, we're going to ignore the Seventh Amendment, and by the way, it's not a big deal. Okay, there's very little that ever comes up about the Seventh Amendment. It's a big deal to the framers of the Constitution, but not to most other people. Seventh Amendment's like the Third Amendment, quartering of soldiers, you know, hasn't stood the test of time very well. Okay, so let's go to the Sixth Amendment. The Sixth Amendment's long, but there's just a couple of things. You have a right to an attorney, is number one. You have a right to legal counsel. You also have the right to confront witnesses against you, and you have a right to a trial by jury. So, right to a legal counsel, you have a right to an attorney, okay? So what's the big deal about this? Well, this is actually a very big deal. You have a right to have an attorney represent you. And it's important to note that your attorney does not have to be competent. Okay? All you're given is the right to an attorney. You're not given the right to a competent attorney. So be careful if you're ever in this situation that you get an attorney who is competent. Okay? Just the way it goes. Next. Oh, I'll tell you a quick story about that. There was a guy who was facing the death penalty, his attorney, and he fell in love. And after hours, attorneys have privileges with their client. They can get together, and after hours, they had some pretty vigorous sex on a regular basis. And as a consequence, during the trial itself, the attorney, she fell asleep. And so she largely slept through the trial. The defendant was found guilty, sentenced to death. He appealed his conviction all the way up to the Supreme Court. And he says, I have a right to an attorney who's awake. And the Supreme Court said, no, you have a right to an attorney, not an attorney who's awake. So he got the death penalty. She got kicked out of the legal profession. Okay, next, you have Sixth Amendment, the right to confront witnesses. Someone's going to accuse you of something, you have a right to go before them and say, I want to see you. I want to ask you questions. This causes a real problem in child molestation cases, child abuse cases, and also in domestic abuse cases, because often the victims of that abuse, the children, spouses, girlfriend, whatever, they are scared to death to confront their, or to be confronted by the people who did it. My brother, as a prosecutor, hated domestic abuse cases because he would get the woman and make sure she's okay and bring her into the courtroom. And that would be the first time since her boyfriend or husband was arrested that she'd actually seen him. And she'd bring him in. I mean, my brother would bring the woman in, and the victim would see the man, and she sometimes wouldn't testify. Sometimes she just left. She ran away. So it's a really tough situation. One of the things that they do for child abuse cases, and we have it here in Taylor County, is we have basically a room where they can testify and another room where the victim can sit. The attorney would go and confront the accused, but the victim would be outside and watching on a two-way screen. So that's a tough part of the Constitution. And the other part, trial by jury. Okay, for crimes, if you're going to have crimes, trial by jury. Um, what is a jury? Why is there 12 people? Does the verdict have to be unanimous? Who sits on a jury? College students here in the state of Texas are automatically excluded. Not automatically, you have to apply, but they can be excused from jury duty. College professors, no, we have to go. Okay, just the way it is. You talk about a jury of your peers. Who's a jury of your peers? Reality is a jury of your peers is just ordinary citizens in your county. That's it. Why are they your peers? Okay. It's just that they're considered to be, but are they really? I don't know. Again, I can use my brother as an example. When he was prosecuting a lot of cases, he said his ideal jury was a jury in which you get rid of any college professor because they think when you don't want them to think. They have their own theories, their own ideas. You just don't want them. He said you also, in California, college students are not excluded. He says you don't want college students because they often lack life experiences. He says his ideal jury is a jury made up of women who are mothers of young kids. And he says, give me that jury, I'll get a conviction. Why is that? Number one, because they're mothers of young kids. They're really concerned about protecting the kids, so they care deeply about crime and want criminals put away. Number two, he said, guess what? They're delighted to be away from their kids for a little bit. They get a break, so they're happy to serve. Number three, they're going to miss their kids, so they don't want to serve that long. So they're going to listen to the evidence, vote to convict, and do it quickly and get out of there. That's his ideal jury. Okay. By the way, the Supreme Court last month said that the verdict in criminal cases has to be unanimous. Certain states had allowed for a 10-2 decision. Supreme Court said no, it's got to be unanimous. Okay, so we know it has to be unanimous now. Okay, that takes care of the Sixth Amendment. Let's go to the Eighth Amendment. Eighth Amendment says you cannot have excessive bail. So if you're arrested, you're going to be charged with a crime. You go before a judge. You get to hear the cases. It's your habeas corpus rights. You get to hear the charges against you, and you know the judge can set you free until the trial. Sometimes they put a bail on you. They say, okay, you need to put $5,000 down. If you come back on the day of your trial, we'll give you the $5,000 back. Okay, that's what bail is. But if your case was like stealing at Walmart, stealing $100 at Walmart, and the judge gives you $1 million bail, so you're stuck in jail. Well, that's excessive bail, and that's prohibited by the Eighth Amendment to the Constitution. The critical part of the Eighth Amendment is really the next part. No cruel or unusual punishment. And that's prohibited. So what is cruel and unusual punishment? Supreme Court's been arguing about this forever. Okay? Most of the time this is applied to the death penalty, but it's also been applied to other cases. In some cases, some states have said if you have 3 felony convictions, you get sentenced to life in prison. It's called 3 strikes and you're out. Is that cruel and unusual punishment? Well, one point, the answer was no. There was a guy who went to Walmart 3 different times, stole some videos 3 different times. Total value of the thefts is probably $80. California sentenced him to life in prison. 3 strikes and you're out, 3 felonies, and he was out. And is that constitutional? Supreme Court said, yeah. It's not cruel, not unusual. You just blew it, dude. Okay. What about the death penalty cases? Basically, it comes down to this. The state cannot hurt you, but the state can put you to death. So for punishment, they cannot hurt you, but they can put you to death. That's really where we come down to. Supreme Court has held that if you're under 17 when you committed a capital murder, you cannot receive the death penalty. They said if you're under 17 and you've been sentenced to life in prison, you can appeal that sentence because it might be cruel or unusual. Okay, let's see what else. The Supreme Court has said if your IQ is below 70, you cannot receive the death penalty because you don't understand what's going on. There was a case here in Texas. A guy was sentenced to death. Okay, you know how you get a last meal? He got his last meal. And at the end of his last meal came time for dessert. He took the dessert and he put it aside and he said to the warden, I'll eat that dessert after you do what you're going to do to me. And it was like, wait a second. Doesn't he understand what execution means? Doesn't he understand the death penalty? The warden is going to kill him. You don't get dessert after that death. So it raises a question, why are we executing someone if they don't understand what the penalty is? Okay? So the idea where the Supreme Court's moving to is the idea that the death penalty has to be given to people who understood the crime that they were committing and understand the penalty that they're getting. Okay? And that's called an evolving standard of decency. I should write this down. I think this is important. So we're talking Eighth Amendment. Eighth Amendment, evolving standard of decency. So the Supreme Court says there were things that were acceptable in terms of the death penalty 200 years ago. Drawn quartering, the guillotine. They're no longer acceptable today. Okay, so that's where the Supreme Court really comes down. So you know there are 5 ways to kill someone that are currently allowed under the Constitution. Okay, those are hanging, still allowed, a firing squad, electric chair, gas chamber, and also lethal injection. In Texas, we use the lethal injection, and the lethal injection has withstood the most congressional scrutiny of any of the methods. None of these 5 have ever been declared illegal by the Constitution, but they always raise issues when you go before the court, and there's always questions of whether it is cruel and unusual to use hanging when it has been used so seldom in the last 30 years. So states that really want to execute people, and Texas is number 1 in that, we use lethal injection because it has withstood the most scrutiny by the courts. And in fact, this lethal injection that Texas uses was actually adopted by the United States about 20 years ago when it reintroduced the death penalty. So anything that goes beyond those would probably be excluded. The reality is that some of those, if someone presses it forward, it would be excluded as well. Texas is number 1 in executing people. We execute more than any other state, but the number of people we're executing is going down over time. Okay, support for the death penalty is declining. Still, a majority of Americans endorse it and support it, but there's less support today than there was 10, 15 years ago. Okay, so that's the 8th Amendment to the Constitution. Remember the evolving standards of decency test. Okay, need to just bring up something else. There's legitimate questions about castration. And is castration an appropriate punishment for sex abuse charges? And here in the state of Texas, some people have said those who are accused of rape, sexual abuse, pedophilia, whatever it might be, they should be castrated. Castration, of course, is cutting off their testicles. You can do it surgically, chemically, and what it does is it means there's no sex hormones then that would drive someone to commit those sex crimes. However, there's an argument to be made that those crimes are not crimes of sex, but they're crimes of power. And if that's the case, then castration really doesn't attack the issue at all. But anyway, some people have said we need to castrate these people. There's an argument, hasn't been proven yet before the Supreme Court, hasn't been accepted before the Supreme Court, which is that this is in fact cruel and unusual punishment. And so basically what happens here in Texas is there's no provision for castration. But if an inmate who's convicted of one of these crimes wants to voluntarily do it on their own and pay for it on their own, they can certainly go ahead. But the state is not going to do it. All right. So that's the Sixth and Eighth Amendments. More later.